What's happening, everybody? All right, you asked for it and you're about to get it. 2026, our 100-question mega pack. This is going to change lives. You're all going to start studying these and passing examinations. Our 2025 series killed it for people, helped all kinds of people all over the United States. These questions are good for any state, anywhere, all the time, always. These are going to help you. Now, just as a little bit of a disclaimer, the 2025 questions are still perfectly fine. And so these are algorithms and consumers thinking that something has updated or changed. But these are new questions for 2026. These are the classic questions that you're going to need to focus on for the examination. Good luck. We're going to release these in 4 parts. This is part number 1 of the 2026 Mega Pack questions. 100 coming your way. In this video, you're going to get 25. We'll see you on the inside. Question number 1. Which condition does a 5-bedroom home with only 1 bathroom suffer from? Letter A, functional obsolescence. Letter B, economic obsolescence. Letter C, incurable physical deterioration. Letter D, curable physical deterioration. And the answer? Letter A, functional obsolescence. So the things that you want to know here are going to be, in terms of, and you'll find this, by the way, in your valuation sections of your books. So look there. You need to know about the different types of depreciation. That's what you're looking at here. These are depreciations. There's functional obsolescence. There's economic obsolescence. And then there's physical deterioration. And so there's 3 of them. Now, there's curable types of depreciation, and then there's incurable depreciation. And that's why they threw that in this question. So incurable physical deterioration and curable physical deterioration are 2 that are pretty helpful to understand. And so you want to know what they are because they're actual phrases. So curable versus incurable physical deterioration. Anything that's curable is economically feasible and is going to continue to improve the valuation of the property potentially. Incurable could be a cost associated that is incurable. You can't get recompensed. So for example, I had a buddy who bought a property in a pretty ritzy area. It was about a $7 million. It was an investment situation. It was a single family home, but the foundation was cracked. And so to fix the foundation, it was going to cost about $3 million. It was quite a property built on a cliff. Really, really fancy. And so if he dropped the $3 million, not necessarily, he couldn't mark the property up by $3 million. So even though they repaired the foundation, the property suffered, you could say, from an incurable physical deterioration because we had a cracked foundation. So this was incurable. Now, functional obsolescence is simply defined as something that is outdated or outmoded. And so a 5-bedroom home with only 1 bathroom is suffering from a functional obsolescence. And so there is a loss of value for that because it's less desirable. And so the less desirable something is, then there could be a direct correlation between the less desirable feature and dealing with it. So now a bathroom might be very inexpensive to fix. And if that's possible, then they can spend it. Then it would be a curable functional obsolescence. If it, let's say, cost, tens of thousands of dollars to put in a new bathroom because of the structure of the house and the plumbing scenario, well, then it could suffer from an incurable functional obsolescence, but then you still might foot the bill to do that because it's going to increase the resale value potentially. So again, you want to know these phrases. Functional obsolescence was the answer there, and we'll see you in the next one. Question number 2. A listing agent is obligated to keep confidential information about the seller's motivations even after the agency relationship ends. This is an example of letter A, obedience. Letter B, confidentiality. Letter C, disclosure. Letter D, loyalty. And the answer? Letter B, confidentiality. All right, so these are simple. These are the fiduciary obligations that we need to know in order to be able to successfully pass the agency section of our tests. And so this is brokerage and agency inside of your books, wherever you're studying this. And so look for those. And there's a couple of easy mnemonic devices. The ones that you learn in all these different books. One is cold AC. I'm going to write that here, cold AC. And then the other one is old car. And basically, they're initialism/acronyms, and they stand for the fiduciary obligations. And remember, fiduciary simply means anything I do or don't do must directly financially benefit my client in some way. I work for the client and I work with the customer. That's what you want to remember. And so old car is this. Check it out. Old car is obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. And then cold AC is similar. It's just care, obedience, loyalty, disclosure, accounting, and confidentiality. And you want to know these for your examination. And what they're talking about in this question is confidentiality all day. Now, in some states, confidentiality must be maintained forever. After the deal closes, you can never divulge information. And in some states, confidentiality will terminate once the transaction has been consummated and finalized. So you want to know that for your state, study that particularly from your books, and we'll see you in the next one. Question number 3. Which loan type is best suited for short-term financing between buying one home and selling another? Letter A, balloon loan. Letter B, FHA loan. Letter C, bridge loan. Letter D, reverse mortgage. And the answer? Letter C, a bridge loan. All right, so this is in your financing sections of your books. You want to know the definition of all of these, actually. Balloon loan or a balloon mortgage, they'll sometimes call these, depending on where you're taking it, who you're taking it with, who's writing the test question. FHA loan, you want to know about the FHA programs. And so remember, the FHA is an insurance on top of loans. So lenders lend money, and the FHA insures these loans against default for the lender. A bridge loan is temporary financing, and you want to know that for sure. And this is sort of like a textbook definition, one of the various. And so which type of loan is best suited for a short-term financing? That is the sort of operative phrase there between buying one home and bridging these two deals. You might need some extra cash, so you can borrow it. So you borrow some money to close on the next property, and then when you sell the previous property, you are able to pay off the short-term financing. These are interim loans or bridge loans. They might call it short-term financing. They might call it interim financing. So look out for that. And reverse mortgages are simply loans to borrowers 62 plus, and they are it's sort of a home equity conversion mortgage, which is the most popular one in the FHA portfolio. So you want to study these definitions, and you should be good to go. We'll see you in the next. Hey y'all, hope you're enjoying these questions. I just wanted to take a few minutes to jump in here really quickly and just give props to my team. My business partner is Kate Tofuri. She's been working in the background since day one of this channel. And Kate's responsible for coming up with some of these great questions, and she comes up with these downloadable materials. And so basically, she's an unsung hero. And I just wanted to take a few minutes to give her some props. And, it's always the folks that are behind the scenes that never get accolades. And I really, I get a lot of, nice comments and thank yous and this and that. And I also just wanted to give her a shout out because she puts in such an effort into making sure that this stuff is great for y'all, and that, we research it and everything else. This whole channel couldn't be in existence without her. So if you can think about it, make sure you give her some props every now and then. Say, hey, yo, Kate, great job. I absolutely appreciate everything she does. And if she wasn't around, this whole thing wouldn't be here. So I just want to take a few minutes to express my gratitude, and we'll see you in the next question. Question number 4. What is the purpose of CC&Rs in a homeowners association? Letter A, to set tax rates. Letter B, to regulate property use and aesthetics. Letter C, to create easements. Letter D, to determine ownership rights. And the answer? Letter B, to regulate property use and aesthetics. So this is interesting. CC&R stands for covenants, conditions, and restrictions. This is a phrase that's in like every book that you're going to find. You need to know about condominiums and homeowners associations, and they go hand in hand. HOA, the homeowners association, and the CC&Rs. So you definitely want to know these for the exam. And fundamentally, this is what they do. They regulate the property use and things like aesthetics. And in terms of setting tax rates, they don't do that. CC&Rs, they have nothing to do with the big picture government. the municipality handles that. To create easements, easements are created, or the right to use the land of another, through the deed system, so through titling and etc. So that has nothing to do with CC&R. Easements could technically be possibly created, or the right to use the land, but they wouldn't create easements. They would be more like bylaws inside of the CC&Rs. And then to determine ownership rights, that's deeds and the relevant paperwork in the world of title. So B is to regulate property use and aesthetics. CC&R stands for covenants, conditions, and restrictions. Question number 5. Which fiduciary duty requires putting the client's interest above all others? Letter A, honesty. Letter B, loyalty. Letter C, disclosure. Letter D, obedience. And the answer? Letter B, loyalty. Again, this is one of those fiduciary obligations. You're gonna see these. These are absolutely present throughout the exam. Hopefully these are fairly easy for you. You just have to kind of memorize these a little bit and read like a paragraph on each of these to really understand them. But loyalty, one of the textbook definitions, is requiring putting your client's interest above all else. So this is pretty important. And remember, the fiduciary duties can be encapsulated in the cold AC, care, obedience, loyalty, disclosure, accounting, and confidentiality. Question number 6. Which type of lien allows the IRS to claim all assets of someone owing back taxes? Letter A, mechanics lien. Letter B, general lien. Letter C, specific lien. Letter D, judgment lien. And the answer? Letter B, general lien. Okay, so you want to know that the IRS placing a lien on your property gives you a general lien situation. A general lien means it affects all property, not just a real piece of real estate or something like that. A specific lien, on the other hand, to contrast or compare against a general lien, it only affects that specific parcel. So a real estate tax lien would be a specific lien. A general lien would be an example of an IRS, which gives claim to all assets. If it says something like that, all assets, when someone owes back taxes, it would create a general lien. A mechanics lien is for contractors. You want to know these for sure. General lien is the correct answer here. Compare that to a specific lien, a real estate tax lien. All right, real estate tax. An example there. And a judgment lien is something that you are awarded in court. Now, in some jurisdictions, the judgment lien could be a local municipality suing you. They might have to do that in due process. Or if it's a governmental entity, many times they just get the right to attach a lien and it becomes a super lien. And in this case, it's general lien. Question number 7. A borrower finances a $400,000 home with a 10% down payment. The lender charges 2 points at closing. How much are the points? Letter A, $7,200. Letter B, $4,000. Letter C, $8,000. Letter D, $3,600. And the answer? Letter A, $7,200. So with these types of questions, pretty straightforward. You do just want to remember a couple things. They actually structure these questions very similar. You know, you're going to find this, if you have the math, very similar in sort of how they approach this stuff. And the incorrect answers are also very, very similar. We're looking at a borrower finances a $400,000 home. So in other words, the total purchase price was $400,000 and the borrower put down 10%. So the first step is going to figure out what is 10% of $400,000 and then subtract that from the purchase price. Or you could just go, you know, what is 90% of the $400,000? It's the same difference. It's 6 to 1, half a dozen to the other, how you get there. But the big trick here is they're going to take this number. And if the student remembers, hey, 2 points, each point is 1% of the loan amount, then, you know, that's sometimes the red herring or the number one wrong answer is going to be 2 points of $400,000. And and then somebody's going to pick $8,000, letter C here. Or they're gonna only get halfway, and they're gonna go to get letter D. And so in order to do this, you need to subtract. So the first thing I would do, I'm just gonna do it one way. It doesn't matter. You can choose. But 10% of $400,000 is $40,000, and so $400,000 minus $40,000 gives you a $360,000 is what was financed. And so if each point is 1% of the loan amount, this is the loan amount. If each point is 1% of the loan amount, then each point is $3,600. And this consumer paid 2 points or 2% of the loan amount. So $3,600 times 2, and that's going to give you the answer of $7,200. Question number 8. Which duty does a real estate agent owe to customers but not to clients? Letter A, loyalty. Letter B, confidentiality. Letter C, honesty and fair dealings. Letter D, obedience. And the answer? Letter C, honest and fair dealings, or honesty and fair dealings. Okay, so this is, again, inside of agency in your textbooks, brokerage and agency, and sort of these are the duties. And so you want to know the hierarchy. Basically, the idea here is you want to remember that there are clients and there are customers. And then the clients, we owe that cold AC to. Care, obedience, loyalty, disclosure, accounting, and confidentiality. So we can eliminate in this question. It's asking us, what do we owe the customer versus the client? And so the client, the party that we work for, we owe all of this stuff to. And then the customer we work with, and we owe them honesty and fair dealings. And that's pretty much it, being, truthful in the transaction, etc. So we don't owe them a lot if you think about it in terms of fiduciary obligation. And the client is given loyalty. So the loyalty wasn't the correct answer, or confidentiality or obedience. These other three, A, B, and D, were all the fiduciary obligations for clients, and then the remaining one is honesty and fair dealings. So there you go. Even if you forgot that, just remember customer versus client, and we're good to go. Question number 9. A deed must be blank to be legally effective in transferring title to real property. Letter A, delivered and accepted. Letter B, signed by both grantor and grantee. Letter C, recorded with the county clerk. Letter D, notarized and witnessed. And the answer? Letter A, delivered and accepted. So a deed must be delivered and accepted to be legally effective in transferring title to real property. So being delivered means that the buyer, it's been delivered to the buyer and accepted by the buyer. It must be signed, but only the grantor signs the deed. So this is an incorrect statement. Recorded with the county clerk. Typically, deeds are recorded. However, they do not have to be recorded in order for the transfer to have happened. In order to be acknowledged or placed into public awareness, we will record the deed. So that brings public notice. And, recording the deed offers something called constructive notice, but that's not what this question is asking. And then notarized and witnessed. A deed ultimately does have to be notarized. Many times not witnessed or witnessed by the notary. That's fine. However, the reality is the deed needs to be delivered and accepted to be legally effective in transferring title to real property. Question number 10. Which type of loan does not require a down payment and is available to eligible veterans? Letter A, USDA loan. Letter B, VA loan. Letter C, FHA loan. Letter D, HUD loan. And the answer? Letter B, VA loan. So you want to know a little bit about these. You're going to find these in your finance sections, the USDA, FHA, the VA, all of which are going to be, you need to know like paragraphs, nothing huge, but just enough about them and sort of what they are. A little bits of like FHA and VA. You want to know a little bit about that stuff, okay? So you want to know a little bit about them. And then you want to know that they're, HUD loan, not such a thing. The Department of Housing and Urban Development oversees America's housing needs. And so USDA, VA, and FHA are legitimate things. The FHA, by the way, doesn't lend money. So it's a little bit of a trick here. I would be careful here. But the reality here is FHA is an insurance program. The VA is a guarantee program. And then the USDA could originate its own loans. That's the only unique one here. But the correct answer here is eligible veterans through the VA, the Department of Veterans Affairs, VA. So that's the correct answer here. Good question. Question number 11. In a tenancy in common, how do owners hold their shares? Letter A, independently with distinct ownership shares. Letter B, with right of survivorship. Letter C, jointly with equal authority. Letter D, equally automatic transfer to co-owners. And the answer? Letter A, independently with distinct ownership shares. So a tenancy in common, these are parts of the list of co-ownership, and you need to know all of them. So like tenancy in common, joint tenancy, tenancy by the entirety, and community property. So this is where more than one party owns a property concurrently. They sometimes call them concurrent ownerships. So check your books. You want to know a little bit about all of these. And the buzz phrases like how are ownership? How do you hold your shares? Well, a tenancy in common, what's very, very normal about a tenancy in common is that you will have distinct ownership shares. What that means, simplified, is let's say if you and I owned a building together, and let's say I put up most of the money and you put up a little bit of the money. Let's say I put up 90%, you put up 10%. We would have a tenancy in common. Therefore, I would have a deed with my name on it independently of you. We would each have a deed to the property. And then my interest in the property would be 90% in my deed and yours would be 10%. And so independently with distinct ownership shares is how a tenancy in common functions. Now, with the right of survivorship, a tenancy in common has no right of survivorship. Now, what is right of survivorship? Right of survivorship basically means that the surviving co-owners will get your interest when you die. So if one of these forms of ownership has the right of survivorship, for example, many types of joint tenancies have the right of survivorship. Tenancy by the entirety has the right of survivorship, right? And so the tenancy in common has no right of survivorship, which means that when you pass, your interest goes to your estate. It's a bit counterintuitive, and I've covered this in several videos. You are definitely going to see these. You want to know that, and you want to know a little bit about all those co-ownerships? This is a great question. Question number 12. Which contract type is binding on the seller only? Letter A, net listing. Letter B, right of first refusal. Letter C, option to purchase. Letter D, lease agreement. And the answer? Letter C, option to purchase. So you want to know a little bit about the different types of contracts. All of this is in contracts. Contracts, by the way, is the largest section historically on all real estate exams in every state. So you're going to see a lot of contract questions. Check your outlines. But you want to know what an option to purchase is. This is a type of contract. And so the net listing is prohibited. It's not, only binding on the seller. Right of first refusal is not a type of contract. It is a covenant inside of a contract. You'll see many times. Lease agreement is a type of contract. Option is a type of contract. Net listing is a type, could be in, an oral contract or it could be in writing. But so the option contract is only binding on the option or. So you want to know that the seller is also referred as the option or, the giver of the option. So check the definition. This is a good question. Question number 13. What is the best definition of depreciation in real estate? Letter A, loss of value in improvements due to wear or obsolescence. Letter B, a decrease in land value over time. Letter C, reduction in value due to external market factors. Letter D, an increase in property value. And the answer is letter A, a loss in value in improvements due to wear or obsolescence. So you definitely want to know the definition of what depreciation is. You will find this particular definition primarily in the appraisal section. So you want to know what depreciation is for appraisals. You will also, for real estate examinations, many times in the broker's exam, you will need to also know what is sort of tax depreciation as well and figuring out capital gains tax. So you want to know these for sure. Primarily, they're looking for it. Now, both types of depreciation are loss in value. So we can easily look to this definition, the loss in value. That is what depreciation means. An increase in value, by the way, is the opposite of depreciation, which is appreciation, right? So there you go. And now, due to wear and tear or obsolescence, this specifically calls to valuation. So check your valuation sections in your book. A decrease in land value over time, reduction in value due to external market factors, and an increase in property value. So this is the opposite. That's appreciation. A decrease in land value. They're only talking about land, not just real estate. So I would X that one out. And a reduction in value due to external market factors. Not only external market factors. That could be, economic obsolescence, or that could be some sort of external market obsolescence factors. Really, the best answer here is letter A, all day a loss in value.
If you're looking to pass the real estate examination in less time, make sure you check out our real estate exam cheat sheet. It's good in all 50 states and focuses on only the need to know concepts for the real estate exam. You're going to find the need to know acronyms and dates, key terms, tips to remember, important concepts, and much more. I'll drop a link in the description below.
Question number 14. Which document provides evidence of a property's ownership history? Letter A, title insurance. Letter B, deed of trust. Letter C, chain of title. Letter D, abstract of judgment. And the answer? Letter C, chain of title. So we want to know a little bit about this. This is the evidence of a property's ownership history. So if it's anything with ownership, that's some sort of title. And this is in the world of title, by the way. So deeds and title are typically the chapters that you'll see named here. And so you want to know a little bit about this stuff. You want to know what the definition of title insurance is, and a deed of trust, and an abstract of judgment is something that you will not see. This is just a bit of a throw off. It looks fancy, but it's nothing to do with it. A chain of title is the only thing here that links every previous owner to the next owner in one continuous link. And that's called a chain of title, which is really looking at the history. You will see that phrase in the definition of ownership, and you want to know that for your exam. Question number 15. Which of the following is not a federally protected class under the Fair Housing Act? Letter A, age. Letter B, disability. Letter C, familial status. Letter D, race. And the answer? Letter A, age. So you need to know protected classes for two anti-discrimination laws for this exam. Number one, you want to know the protected classes for the Fair Housing Act. And number two, you're going to want to know the protected classes for the Equal Credit Opportunity Act. Now, at the state level, depending on the state that you're in, the state will have different protected classes in addition to the federal law. So the way the states can operate is there's a federal Fair Housing Act, and that has 7 protected classes. And the state at minimum has to adopt the 7 protected classes at minimum and can include more protected classes. So many of the states that you're going to be taking these in have more than just those 7, and some states just have those 7. You need to memorize those for sure. So the federal Fair Housing Act, it's going to tell you that, right? Unless it's a state-specific test question. Federal Fair Housing Act is race, color, religion, RN for religion, race, color, religion, national origin, sex, familial status, and disability. So there's your 7. And again, you want to also know the ones for the Equal Credit Opportunity Act. I'll write ECOA here as well, so learn the protected classes. You want to know those. And then you want to know that disability is a protected class, familial status, and race. These are all 3 protected classes, so check, check, check. Age is not. However, age is protected under the Equal Credit Opportunity Act. So you want to know those. Question number 16. Which valuation principle says buyers won't pay more than an equal substitute property? Letter A, contribution. Letter B, substitution. Letter C, highest and best use. Letter D, regression. And the answer? Letter B, substitution. So you want to know these principles of valuation, and you'll find these in your appraisal section throughout your book. And so you want to know the basic definition. Now, substitution is by far the biggest one you want to define. So really, that's one of the ones. I'll just put a little star there. Highest and best use, regression and progression and contribution are all economic principles of valuation. And you want to study these, read through them, read the paragraphs, and just do questions like this. You're going to understand these, but these are definite types of questions that you're going to see on these examinations. So be on the lookout for these. Question number 17. A property owner allows a neighbor to cross their land to access a road. This creates letter A, encroachment. Letter B, easement. Letter C, ordinance. Letter D, deed restriction. And the answer? Letter B, easement. So easements, encroachments, deed restrictions, these are all pretty popular. Ordinances, you might see, you typically don't see ordinances on the exams many times. They're not even many times on the outlines. Maybe CC&Rs are, covenants, conditions, and restrictions. So you want to know what these are. And this one here seems to be the textbook, one of the variants of a textbook definition of the ability for someone to cross their neighbor's land to access the road. And so the definition of an easement is the right to use the land of another, and you want to know that. Also know the definition of encroachment and what a deed restriction. Sometimes with deed restrictions, they might call these CC and R's as well. So look out for that, but easement here is the answer. Question number 18. A hidden property defect not easily discoverable is called letter A, material fact. Letter B, functional obsolescence. Letter C, latent defect. Letter D, easement defect. And the answer? Letter C, latent defect. So anything that's hidden would be considered a latent defects, hidden structural defects, not easily discoverable. This is very textbook. Look up latent defects. The opposite of a latent defect is a patent defect. So, that's something that's glaringly obvious. And so you want to know the differences between latent defect and patent defect. These are very popular on examinations. Good to go. Question number 19. Which law prohibits housing discrimination based on disability? Letter A, ADA. Letter B, Fair Housing Act. Letter C, RESPA. Letter D, ECOA. And the answer is letter B, Fair Housing Act. So we want to know these several laws for the examination. You're going to need to know a few more, like truth in lending as well. But you want to know, like Americans with Disabilities Act, that's an actual thing that deals with disabilities. However, the question here is asking which law prohibits housing discriminations based on disability. The key trigger here is housing discrimination. And so the ADA covers and protects persons with disabilities in commercial environments. And so the ADA deals with commercial and access for folks with disabilities. And then the Fair Housing Act is dealing with housing discrimination based on disability. The Equal Credit Opportunity Act is another type of anti-discrimination law that primarily affects lenders. And in RESPA, which is an actual thing, is the Real Estate Settlement Procedures Act, deals with settlement providers in the world of settlements and closings. RESPA doesn't have anything to do with this type of thing. It's discrimination. But the number one wrong answer, the number one would have been ADA, and the number two wrong answer would have been Equal Credit Opportunity Act. But the Fair Housing Act is the correct answer.
Hey everybody, D here, and I've got some amazing news. My premium practice exam course is available right now. Now, this used to only be available with my high ticket course, but now you can get it on its own. You get basically my best 200 practice questions with video explanations, and I've got to tell you something, this has been one of those super popular resources for my private tutoring groups all the time. I'll drop a link in the description below so you can check it out on your own.
Question number 20. A lender requiring full loan repayment after default uses which clause? Letter A, habendum clause. Letter B, alienation clause. Letter C, acceleration clause. Letter D, balloon clause. And the answer? Letter C, acceleration clause. So the covenants inside of a mortgage, there's several. And then there's other covenants that you learn in this study of real estate brokerage and your salesperson's examination. So the habendum clause is a legitimate thing, but that applies to deeds, habendum clause. That means to have and to hold. I'm just going to write deeds primarily. I mean, other types of documents do have habendum clauses, but habendum clause deals with deeds. Alienation clause deals with mortgages. I'll write M. And acceleration clause deals with a mortgage lien. And then balloon clause is also something that you will see inside of a promissory note or a mortgage transaction. However, the balloon clause typically is going to be in the promissory note, just FYI. So that's clearly the not correct answer. Really, the choice will be always, when you look at students, when you learn these, is going to be between B and C. An acceleration clause is a clause where the lender can demand the full payment after default. And so default will trigger the acceleration clause. And then if the seller sells their property, then the alienation clause is a due on sale clause. That's another very popular one, due on sale. So you want to know these for sure. An acceleration clause, this is a classic acceleration clause. The word default is the trigger, so look out for that. Question 21. Which form of ownership is exclusive to married couples and includes survivorship? Letter A, tenancy by the entirety. Letter B, tenancy in common. Letter C, life estate. Letter D, joint tenancy. And the answer? Letter A, tenancy by the entirety. So this is co-ownership again. And we looked at co-ownership a little bit ago in one of the previous questions. You want to know all of the different types. There was 4, tenancy in common, joint tenancy, tenancy by the entirety, which was this question. And then you also want to know about community property and their definitions. And you would definitely want to know that, which ones have the right of survivorship, which ones do not, what is the right of survivorship, what is not. You want to know all of those. And here, the exclusive form of co-ownership for married couples. It just even says it in the question, and it includes survivorship. Survivorship, again, remember, means if one party dies that owns the property, then the surviving co-owner gets that interest of the deceased party's interest. No right of survivorship means it'll go to the deceased party's estate. And so one of the reasons why they couple, pun intended, I guess, the tenancy by the entirety with survivorship is because if one of the spouses passes away, the other spouse automatically becomes the owner, and they don't have to go through the probate process to be able to prove this. If the deed says entirety, then the changeover is instantaneous, and it's accepted so long as you submit the death certificate, and then the surviving spouse can just sell the asset if they need to in a pinch. Usually that could be the case. Question number 22. What type of lease requires the tenant to pay rent plus certain property expenses like taxes and maintenance? Letter A, net lease. Letter B, gross lease. Letter C, percentage lease. Letter D, sublease. And the answer? Letter A, net lease. All right, so in the leasing units that you will typically see, there are several leases that you will see definitionally, I guess, and you want to know these. So you want to know net lease. Sometimes they'll refer to it as triple net, and sometimes if it's a triple net lease, that means the tenant will pay rent plus all of the expenses. And this one is saying certain property expenses. So many times they'll just simply reduce this to a net lease. So in a net lease situation, the tenant pays rent plus some type of additional expenses in addition to the rent. In a gross lease, compare the tenant pays a fixed rent and the landlord is covering the operating expenses and the other costs associated with the property. A percentage lease deals with retail and sales. And then a sublease is a lease inside of a lease. And so you want to know these definitions. Net lease is clearly the one that you want to know here. And sometimes they'll refer to this as triple net if all the expenses are also paid by the tenant. Question number 23. Which type of listing allows multiple brokers, but only the successful ones earn commission? Letter A, open listing. Letter B, net listing. Letter C, exclusive agency. Letter D, exclusive right to sell. And the answer? Letter A, open listing. So this will be in the brokerage/agency units in your books. You want to know the definitions of all of these. Open listings, net listing. These are typically not allowed. So net listings are where the seller is looking to net a specific dollar amount, and anything that the agent can sell the property for above that number, the agent can keep. These are prohibited in many states. So you want to check your states here. Exclusive agency versus the exclusive right to sell. These exclusive agencies are only hiring one specific agency or one brokerage. And this is asking us which type of listing allows multiple brokers, not one. This is one and this is one. Listing not allowed, and then the only successful one earns the commission. That's an open listing. Open listing is basically tantamount to first come, first served. Whoever can find a ready, willing, and able buyer to act on the seller's conditions or the landlord's conditions, and they close the transaction, will get paid the commission, and that is open listings. In many city environments like Boston and New York, you'll see these open listings where more than one house has the listing, and it's the first one that brings a deal that the landlord accepts will get the commission for that. Question number 24. Which deed provides the highest level of buyer protection? Letter A, general warranty deed. Letter B, bargain and sale deed. Letter C, quitclaim deed. Letter D, special warranty deed. And the answer? Letter A, the general warranty deed. So we want to know the definition of all of these deeds. These are on there. And you'll see this in the deeds/title sections of your textbooks, wherever you're studying this. Hope the studying's going well, by the way. And so the general warranty deed, the big key thing here is you want to know that the general warranty deed offers the most protection to the grantee. I'm going to write grantee here, because sometimes instead of buyer, they might refer to it as the grantee. So you want to make sure you know who is the buyer, who's the seller, grantor, grantee. You want to know that the grantee is protected. And the bargain and sale deed, not so much so. The quitclaim deed typically cures clouds on title, and the special warranty deed, some states use this as a deed of conveyance. And you want to know the differences here, but all 5 of the deed promises are contained in a general warranty deed. So basically, the buyer accepting a general warranty deed is going to get this maximum protection that will even predate the seller. So if anything were to come up to affect the ownership or the rights of the property, not only would the seller have to defend, but any previous owners could potentially be required to defend or clear issues in the event that the buyer has some sort of a lien or cloud on title. So again, the general warranty deed offers the grantee or the buyer the highest level of protection. You want to study all of these deeds. Question number 25. In a title theory state, who holds legal title until the mortgage is repaid? Letter A, the lender. Letter B, the trustee. Letter C, the borrower. Letter D, a remainder man. And the answer? Letter A, the lender. The lender is also referred to as the mortgagee. So I'm going to write E, the mortgagee, the mortgagor, and the mortgagee. The mortgagor is the borrower. So the mortgagor is also referred to as the borrower. So in a title theory state, and you will learn lien theory versus title theory in the finance sections, in the basics of finance, or mortgages 101 is typically where you're going to see this. You're going to see lien theory versus the title theory. You want to know the definitions of both. And in a title theory state, then the legal title is held by the lender until the mortgage is repaid. It could also be held by a trustee in a deed of trust. That's another phrase I'll write here. And so we want to know these phrases as we're sort of learning these things. But the lender, or they could refer to the lender as the mortgagee. So look out for that. It's a great question. All right. That was 25 questions of our 2026 version of the 100-question mega pack. 2025 is still rocking, by the way. Those are perfectly fine. Study all these questions. We're releasing 2026 questions in 4 parts. That was part number 1 of the entire mega pack. 25 questions for you. Focus on the questions, focus on the answers, focus on the explanations. If you have any questions, drop them in the comments. Thanks again for tuning in. We hope 2026 is a successful year for you all and you're passing examinations. Let us know. Don't forget to hit that subscribe button. Thank you very much for all the support. See ya in the next